As I've said repeatedly in other videos, the UDRP, or Uniform Domain Name Dispute Resolution Policy, is the oldest and most popular domain name dispute policy. But it has one significant limitation that keeps trademark owners from using it even more often to fight cybersquatters. It does not apply to all country code top-level domains, or ccTLDs, such as .uk, .us, or .ca. However, many countries have adopted their own versions of the UDRP or other policies that still allow trademark owners to shut down problematic domain names around the world. Hi, I'm Doug Isenberg, an attorney and founder of GigaLaw, a law firm that helps clients protect their brands on the internet. In this video, I'm going to review when the UDRP applies, when it doesn't apply, and provide a broad overview of some of the important ccTLD dispute policies that trademark owners can use to combat cybersquatting if the UDRP is not an option. As a reminder, the UDRP applies to all of the so-called legacy TLDs, such as .com, .net, and .org. It also applies to all of the new global or generic top-level domains, those GTLDs that were created as part of ICANN's expansion of the domain name system in 2012, resulting in the addition of more than 1,000 new top-level domains, such as .xyz, .london, .pizza, .shop, .online. Finally, the UDRP applies to about 40 of the ccTLDs, such as .co for Colombia, .me for Montenegro, and .bs for the Bahamas. But there are more than 250 ccTLDs, so obviously that means most countries have not adopted the UDRP. These non-UDRP countries can be divided into roughly 3 categories. Countries that have adopted a variation of the UDRP, countries that have adopted an altogether different domain name dispute policy, and countries that have not adopted any sort of a domain name dispute policy at all. Now, I can't review a couple hundred countries in this video, so instead I want to focus on the big picture. In practice, when I'm discussing a specific cybersquatting problem with a trademark owner, I always dig down into the details of the applicable ccTLD dispute policy. But here, I just want to introduce the general categories of ccTLD disputes. First, about 40 countries have adopted a variation of the UDRP. This list includes .au for Australia, .br for Brazil, .ch for Switzerland, .cn for China, .eu for the European Union, .fr for France, .ir for Iran, .mx for Mexico, .nl for the Netherlands, .se for Sweden, and .ua for Ukraine. In some of these countries, the applicable dispute policy differs only in a minor but very important way from the UDRP itself. As you'll recall from my earlier videos in this masterclass, the third part of the UDRP's 3-part test requires a trademark owner to prove that a domain name was registered and is being used in bad faith. And as I said before, the word "and" in this context means that a trademark owner must prove both that the disputed domain name was registered in bad faith and that it is currently being used in bad faith today. Now, this creates real challenges in some cases, such as if a domain name was created before the trademark owner's rights existed, even if the domain name is being used in some sort of egregious manner right now. So, in some of the ccTLD dispute policies, the word "and" has been replaced by the word "or." In other words, a trademark owner only has to prove that a disputed domain name was registered in bad faith or that it is currently being used in bad faith, not both. This simple replacement of a single word makes these ccTLD dispute policies even more attractive to trademark owners than the UDRP itself. Some of these ccTLD dispute policies that are based on the UDRP also include other changes, such as requiring a specific language for the dispute process, requiring a trademark owner to have rights in certain countries, including a process for mediation before a dispute is submitted to a panel for a decision, or even setting a sort of statute of limitations that requires a trademark owner to file a complaint within a certain period of time. So, That's the first category of ccTLD dispute policies, those that are similar to the UDRP in many ways, but contain some important differences. Second, many countries have adopted their own domain name dispute policies that are not based on the UDRP. Instead, these policies include legal tests that are different than the well-known three-part test set forth in the UDRP, which I have described in detail in previous videos in this masterclass. For example, one of the most popular alternative policies is the so-called Dispute Resolution Service, or DRS, that applies to the .uk ccTLD for the United Kingdom. Under the DRS, a trademark owner has to prove that a disputed domain name is an abusive registration in the hands of the respondent, and the DRS includes a detailed definition of what constitutes an abusive registration. And Germany takes an interesting approach to disputes for .de domain names, which allows a trademark owner to place a so-called dispute entry on a domain name by submitting specific evidence. This prevents the registrant from transferring a domain name to anyone else for a certain period of time and enabling the trademark owner to obtain the domain name if it is released. So, that's the second category of ccTLD dispute policies, those that have taken their own approach and are not modeled on the UDRP. Third, and finally, a number of countries have simply failed to adopt or enforce any domain name dispute process whatsoever, which typically means that a trademark owner has to resort to traditional litigation to enforce its rights, which is often time-consuming, expensive, and uncertain. In Russia, for example, .ru disputes must be resolved in court. And in Cameroon, where the .cm top-level domain is frequently exploited by cybersquatters because of the similarity to .com, a dispute policy seems to be largely ignored, frustrating some of the biggest trademark owners and leaving them without any viable remedy to enforce their rights. Fortunately, most countries offer some sort of domain name dispute process, so trademark owners are usually able to tackle most cybersquatting problems. In my experience, deciding whether to pursue a specific ccTLD dispute usually requires an evaluation of many factors, including where the parties are located and how a domain name is actually being used. To learn more about domain name disputes, I invite you to take a look at other resources on my website at www.giga.law, where you can also subscribe to receive a daily email newsletter about important developments in Internet law. Thank you.